Good afternoon, everyone. Apologize for the delay, but we're here to discuss House Bill 402 from last session. What I thought we'd do, this is kind of a unique time, as we've discussed before, with regard to other legislation in previous years, really, but it affords us the ability on certain issues to use the time that we have between now and the end of the year to hopefully forge consensus on some issues where you may have some division of opinion. I know that there's certainly a good number of advocates. There may be some folks who have, or some groups that have some concerns. I know that some of the nonprofits have been involved in this. I know the prosecutors are taking a look, and of course the defense bar has been working on this for a while. This bill was put in late last year, and that's not by way of criticism in any way, shape, or form, but I think just in terms of the timing of the bill going into the process didn't help it, but by the same token, we are here now. The Vice Chair introduced this bill, and we considered it here in the committee and passed out a committee substitute, if I recall correctly, late last session. So what I thought we would do is, to the Vice Chair, what I thought we would do is maybe to have you speak to the bill again. I don't think we necessarily have to do a section by section, certainly, but to talk about it at 30,000 feet from a conceptual standpoint. What's the intent? Where are we going? What's the public policy imperative that that is intended to be reached, with the bill? If there are any issues that you know of off the top of your head that you can speak to and would like to speak to, fine. You're under no duty to do so. I think probably what I'll do at that time is if anyone, if there are any interested parties that want to have that express themselves on a particular issue or two, pro or con, I think that would be helpful just for the committee and also for the author, so that those interested parties can get together between now and the end of the year, again, to see if consensus can be forged. And I think when you take that time and do that, you inevitably end up with a better work product, and that's the name of the game around here. So, with that, Mr. Vice Chair, let me ask you to, if you could, give us a descriptive on it, and take a few minutes and do that, and then we'll just march on from there.
Okay, thank you, Mr. Chairman. This is House Bill 402, and we're working from the substitute LC 294773S. This is basically a bill that has come about to try to revise and restate our expungement procedures under Georgia law. Expungement right now is a process that is fairly nebulous, and it really does not provide relief for many people in many situations. It is a relatively limited remedy that's available, and current law throws the expungement process primarily into the laps of prosecutors to have to deal with. And I'm not here to speak for the prosecutors, but in previous discussions with prosecuting attorneys, it had been our understanding that the prosecutors really wanted to be free of that process in having to deal with the sort of all the paperwork and all the workload that would go along with making those decisions and administering that process. And so, to a great extent, this proposal is going to take that out of their laps. Now, they may say, and I don't know what they're going to say. I assume we've got some here today that will talk, and they may say that they've decided that they want to keep it, and if so, then we're going to need to, take a look at how this proposal might be revised. But there's little doubt. I think there's a universal agreement that the expungement procedures we have under current law do not fit the bill when you take into consideration that there are not any procedures for a person whose case who was, for example, found not guilty by a jury. There's nothing there for that would allow an expungement in that situation. And a lot of people who have cases that for one reason or another were null pros, dismissed, were disposed of with an acquittal, whatever, they find themselves in positions where they can't find employment because a criminal history report turns up and says this person was charged with X, Y, or Z. And, obviously this is not a procedure that is designed to expunge records of people who are violent criminals or that have done something that has actually resulted in a conviction. That's not at all the purpose of this. But this is to deal with those situations where people have been arrested and have had some disposition short of a conviction that would entitle them or would give them the right to come in and say, hey, give me the opportunity to have this expunged so that I can go to work, get a job, do any number of things that a criminal arrest designation would otherwise prevent. So just to kind of go briefly through the bill, I wanted to start sort of in the middle of it on page 7. You'll see at line 231 that this is perhaps the principal guts of the bill in determining what information is going to be restricted. Am I right in that? Okay. And as you can see, it divides, it says the center, which is the Georgia Crime Information Center, would restrict access to an individual's criminal history record information with regard to the following types of dispositions. And then it divides that into those prior to indictment or accusation, and then secondly after indictment or accusation. For those prior to indictment or accusation, where the case was never referred for further prosecution by the law enforcement agency, or the case has been closed and the statute of limitations has run in misdemeanor cases or felony cases, and then secondly, where the case was referred to the prosecuting attorney was later dismissed. Either of those would fall within the category where someone would be entitled to ask to have those arrest records expunged. Then secondly, down at line 241, then going over to page 8, after indictment or accusation, we have A, where the case was dismissed or null-prossed, or the case was placed on the dead docket without the consent of the state, and a period of 12 months has expired from the date of placing such case on the dead docket, which are all fairly standard dispositions of cases. B was where the individual was convicted of an offense, sentenced, and then not including the death penalty, but the conviction was vacated or reversed, and that decision has been made final, and the prosecuting attorney has not retried the case within 18 months. And has not taken any other steps to preserve their position. Or finally, where the grand jury returns two no bills, because as you know, under Georgia law, the return of a second no bill results in the attachment of jeopardy. So that's sort of the framework of the types of cases that are generally going to be eligible for inclusion. Then we go back over to page. Get to it here. Page number 6, and this bill provides procedures by which, beginning at line 181, if an individual believes his or her criminal history record information to be inaccurate, incomplete, or misleading, that he or she may request an inspection of the records, and the center is going to be obliged to provide that information. There is a fee that would be included of up to $15 for the provision of that information. And then in line 192, if the information is believed to be inaccurate, incomplete, or misleading, then the individual may request the entity having custody or control to modify it or correct it, supplement it, or even under some situation may seal the information and then notify the center of changes. There is a provision when an agency declines to do that, then an appeal can be taken to the Superior Court, I believe. Is that right? That's Superior Court. And those would be taken in the same manner as appeals from the probate court. and it would basically be a hearing that could be heard in chambers by the judge. Then the court, upon issuing a decision within 60 days, and this is line 213 on page 7, would make a finding by preponderance of the evidence whether or not the information falls within the category of inaccurate, incomplete, or misleading, and then can enter a judgment that would be remedial. And that, of course, that decision by the court would be appealable to the appellate court if there is a failure to receive relief there, and that would be an appeal of right under Code Section 5-6-34. Then going over to page 8 and looking at subsection J, we pick up here where a separate process where an individual may petition the Superior Court to restrict access to criminal history record information, and it provides the method by which the petition would be filed and served. The court holding its hearing and granting an order, granting or denying the request within 60 days, and then provides for an appeal, a direct appeal under 5-6-34 there. Then, let's see, any other highlights that we need to go over? Right, okay. Right, subsection I, we need to cover line 253 on page 8. We need to make clear that there are certain types of records that would not be subject to be restricted, and those would be as follows. One, where the charges were null pros, dead docketed, or otherwise dismissed because of a plea agreement that resulted in a conviction for an offense that arose out of the same transaction or occurrence as the record in question. Secondly, where the charges were tried and some but not all of the charges resulted in an acquittal. So if you're acquitted of, if you have 3 charges that are transactionally related and then you're acquitted of 2 of those are not going to be subject to expungement if you're convicted of the third. It is essentially what that means, and that would get to the cases where a jury, perhaps, although they're not to do this, the reality of it is that inside the jury room, the juries may reach some compromise verdict or something, and so the point is that there's conduct that's deemed to be criminal at least on one count. And we don't want to restrict access to that, of course, and so you can't have something that's transactionally related to that, which would be suppressed from the public view. Then third, the conduct which resulted in the arrest of the individual was part of a pattern of criminal activity, which was prosecuted in another court of this state, the U.S., or another state, or a foreign nation. And then finally, where the individual had diplomatic, consular, or similar immunity from arrest or from prosecution, which resulted in the failure to be able to bring a charge against a person. So they couldn't come in if you had a foreign diplomat that came on United States soil and committed a crime, but they were subject to immunity from arrest or prosecution as a result of that. Then they could not use that, they could not ask for that arrest in the event of an arrest. They could not use that arrest as a basis for expungement because the immunity was present. In other words, the state would be prohibited from pursuing a prosecution further because of immunity, and solely because of immunity, and we don't want to give them the benefit of expunging their record because of a procedural obstacle like that. Mr. Chairman, that's sort of an overview or an outline, I think, at this point, without getting into too much detail. And
I appreciate it. What I thought we'd do is, if I see we have one question, we'll go ahead and field that in a second, or maybe a couple, and then perhaps open the floor up to other interested parties if they wanted to go ahead and you've highlighted where the bill's coming from an intent standpoint, and then some of the details which inevitably, should this bill move forward, will change over time as the process dictates. But then maybe if we could have some other parties, come up very briefly and to talk conceptually about some areas that they have concerns on, that really gives you as the author notice of whether, obviously, there's going to be some communication between now and the end of the year of where the focal points may be. It's not restricted to that, but what probably you'll start with, put it that way. Mr. Sefton.
Thank you, Mr. Chairman. To the author, I know you've been quite busy this special session.
No, not at all.
Appreciate your taking time to address this important issue. I want to give an example of some related charges that someone could be brought up on. I want to understand if this bill addresses the concern. Let's say, and I'll give you a hypothetical. Let's say there's a charge that's brought against someone for trespassing, breaking and entering, and attempted murder. That someone is maybe those are the charges that were brought together by the prosecutors, because the contention was that someone came onto my property, they broke into my house, and they tried to kill me. Okay, let's say though over the course of the trial, or actually, let's back this up, way before the trial, as the investigation kind of gets started, and they understand what prosecutors come to understand exactly what they really truly have. Even though the person was detained on that, they realize, there's some he said, she said going on here, that yes, the person definitely came onto the property uninvited, but they didn't break into the house. The attempted murder really was the person came onto the property, and the person that the homeowner got very belligerent, and sort of a fight ensued, and the person's quote attempted murder was more of a self-defense kind of action in a kind of a chaotic circumstance. So you've got this case where there's no question there's a trespassing charge, and the person could be convicted for trespassing, criminal trespass perhaps. But the other charges of attempted murder, breaking and entering, are null prost, or not really pursued. Show me in the language here, just give me a comfort level that the attempted murder and the breaking and entering could still be restricted, even though there's a related charge of criminal trespass.
That's under the J. Right. That would be, if you look at line 263 on page 8.
Okay.
And that provides for the petitioning to the Superior Court to restrict access to criminal history information, and the court would hold a hearing on that. I think that there would be some question about what the disposition of it is. I mean, if you're telling me that are you telling me that there's a conviction that results out of that for a criminal trespass?
Let's say that the criminal this is just a hypothetical I made up, but let's say the criminal trespass is substantiated, and they are convicted of that. But this attempted murder thing out there is something the person doesn't want on their record.
Section J would be it's the extraordinary remedy section, where that section allows those charges to be expunged, but it doesn't allow felony convictions. So I think that basically the Superior Court has jurisdiction over the charge for 4 years, as Jay says, and during that time the person can petition the court to say, in that situation, those serious violent felonies on my record are having such a prejudicial effect on me, such that even though I was convicted on the criminal trespass, these things are affecting my ability to get employment or housing or whatever, and that this section allows the court to say, in this extraordinary circumstance, because we're not dealing with a felony conviction, that the court would have the ability to expunge that record.
Okay, but as it stands, in lines 253 through 262, the short and simple is, if there's any conviction
Right, but this is because, because there's a difference between automatic and.
I think what she's getting at is this: we're providing for a procedure where there are certain offenses that are automatically, or certain arrests that are automatically going to be expunged. That we're looking at it from a standpoint of the clerks being able to, when they close a case file, to immediately make a judgment. If there's something subject to be expunged, then they will go ahead and do that at that time, notify the GCIC, and move on it then. But, and this would be something that probably, under the terms of line 257, where if the charges were tried and some but not all of the charges resulted in acquittal, or perhaps it could be under, lines 254 through 257, where it would be a plea bargain. But nevertheless, those would, under the automatic provisions, those would not be subject to expungement.
Correct.
But we're saying that beginning with line 263, subsection J, that the Superior Court would have the power to order expungement.
So if you were initially charged on a fairly low-level crime and a very serious crime, and they get a conviction on the low-level crime, because those two are related, the standard process is that both would be available for everybody to see, even if there was this was completely unsubstantiated.
Right.
And it's 263 provides a remedy for that, but you still, that big ugly still is out there, and because there's something even minor that's related to it that's charged.
Well, but ultimately a judge is going to have to put a set of eyes on that, hear the evidence, hear the facts, and then make a decision as to whether or not those should stay in the public domain or should be restricted.
Ms. Neal.
I think that, Mr. Setzer, your concern was in reference to those charges that are still out there, the person still having to deal with them for at least the 60 days. Is that where you're trying to kind of go on at?
My concern is if there's a fairly trivial offense and a very serious offense that's initially charged, that this very serious one could go away immediately, but because there's a trivial one that you are convicted of, the big ugly one stays around, and you've got to go through this detailed judicial procedure to get it, or relatively detailed procedure to get it expunged. And is that what we're meaning to do? Is there a more artful way of doing that?
Well, I think so, because I think that, well, first of all, I think that's probably rarely the case that you would see that come up. However, in writing a general rule on this subject, it's very difficult, because you don't want to prohibit the public from viewing things where there is potentially serious conduct involved. And so I think a situation like that, there is a remedy there under the procedures under subsection J, but would it involve some extra, perhaps, cost or inconvenience on the part of the petitioner? Probably so.
I won't speak on behalf of the prosecutor, but I imagine a situation where charges are reduced, or someone is tried and they're convicted on a lesser included offense, but that there may be reason to keep those arrest charges on the record for whatever reason, and J allows them the ability to tell the judge, no, those need to stay there.
Mr. Coomer.
Thank you. A couple of questions. One, have you had any input from the Council for Superior Court Judges?
No.
Okay. Just to clarify, in reading through this, I understand that the restrictions would be restrictions on the release from the GCIC, but will the records still be on file at the courthouse and the clerk's office, subject to somebody? I mean, those are public records; anybody can look up. And I understand, there's a difference in getting it from GCIC and going to the courthouse. But are those records, in fact, going to be left open for the public at the courthouse, even though they're expunged or restricted by GCIC?
They wouldn't be available for the public. The entity would be required to maintain the records, but they would be restricted access.
So, and is it in the bill that the restriction of access applies to the clerk's office as well, or just to GCIC?
Yes, it applies to the entity. Let me see if I can find that. I
see on I think
it's in
K, where there's a reference to restricting, or to the notice to law enforcement agency and restriction of the municipal jail or detention center.
Right.
I didn't see anything that related to any other repository of the records, like the clerk's office. Maybe I'm just missing.
Okay.
Oh wait, well, no, maybe.
Back on page 6, under the definition of entity, it includes a clerk's office. That's at line 170. The term entity means the arresting law enforcement agency, other law enforcement agency, including county and municipal jails and detention centers, or clerks of courts office.
Okay.
And K treats, well, I don't know, I'm sorry, I'm working off of several versions, but here's
I think I need you to reintroduce yourself to the committee, if you could.
Sorry, Mr. Chairman. Marissa Dodson, I am the lead coming home attorney at the Georgia Justice Project, and the Georgia Justice Project has been involved in trying to change the expungement statute with Representative Hatfield and others for several years, along with the Georgia Association of Criminal Defense Lawyers. The general issue here, and what we're trying to address, is that issue, is that people are going to get records from other places other than GCIC or the Georgia Crime Information Center. To your point about the county clerk records, as well as the jail records, county and municipal jails. So what we're trying to attempt to do with this bill is, before 35337 just tells the center to restrict access to the, to restrict access to the record, it doesn't say anything about anywhere else. What this bill tries to do is close those back doors so that private background check companies that are using, Choice Point or High Rights and their investigators down there to get them won't be able to get what GCIC doesn't disseminate. So I'm not sure which version you're looking at, but the one that I have, which I think is similar, is K 1 and 2 deal with the county municipal jails and detention centers, and then we have a provision that deals with subsequent to the effective date of the statute and after the effective date of the statute, how the clerk is to deal with those records. I think that's still kind of on the table with regards to them, because we're trying to work out some of our larger concerns with the clerks and their maintaining the records and what will work to get them to close that.
Just, Mr. Chairman, if I may, the lines 290 through 299, subsections 3 and 4 there, seem to address both the pre-effective date and post-effective date situations with regard to clerks of court. So
Yeah, I see it now. I had just missed it before.
okay.
Thank you.
Under the category of better late than never, let me recognize Judge Billy Boyette. Judge Boyette, thank you for being here, and Judge Tom Campbell. Where? You're hiding. Thank you both for being here. Judge Campbell's former Representative Campbell, for those who don't know, represented Roswell in the House of Representatives. Mr. Pack.
Thank you, Mr. Chairman. A couple questions. Line 190 related to the fee capping at $15. I'm a little concerned that we might have to come back and re-explore that. I get a feeling that we might have some county commissioners or they're going to say that's just not enough money. Is there any way to adjust, leave enough flexibility for the locals to charge appropriately?
I think that we had some basis for putting that amount in there.
Right. The current law says $3, so
Okay.
we did increase it to $15 after talking. I think that's the GBI.
GBI was involved in that discussion.
I'm sure we'll hear from them.
Okay. And so that's one thing that popped up. The second thing relates to line 200. It gives the jurisdiction to order GCIC to the Superior Court where the entity is located. I'm afraid that wherever those entities are located is going to get inundated with these petitions. You see that happening several times in the federal system when you have habeas going to wherever the prison is, then that district is overloaded with cases. It might be better to adjust it to wherever that conviction came from so that one county, Superior Court, or whatever don't have to look at all these appeals.
That section is dealing with when you think that it's the entity in that situation would be a clerk's office or a jail or something where you think that they have incorrect information on you, and what we're asking them to do is to the entity we're talking about is where the record is wrong. We want them to have to file in the Superior Court. What we're trying to deal with is I think the way that it was before was allowing you to be where the person was their resident or where the entity was located, and the concern was that we may have someone who lives very far away but has a record that's wrong in another county and forcing somebody from that county to have to go to where that person lives to deal with that inaccurate record. We're making the individual have to go to where that entity is located, and we think that that would be safe within their county. It would require them to not have to travel or have the same type of inconvenience.
But I think what Mr. Pack is getting to, if I'm correct, is you're saying specifically with regard to GCIC's request that's going to dump
Is that in
a lot.
Fulton? I don't know where it is.
It's
Where's it
in
located?
Decatur, I think, isn't it?
So DeKalb. Have you talked to DeKalb Superior Court about whether they like that?
You know, it may be that would be one way of dealing with that would be specifically to provide that those cases involving GCIC be brought in the county of residence of the petitioner. You know, that might be a...
That sounds like that may solve it. Another question. I had a confusion about on page 8. If you look at line 245 to 250, there's a restriction on that one of the types of cases that where you could seek a restriction on disclosure, and it has some time limits on there. And then if you look at line 263 to 265, which you talk about the extraordinary remedy,
Yes.
it gives jurisdiction to 4 years. I'm thinking that might be a little inconsistent when you exhaust appeals, and you get back. And there might be cases when you have 2 retrials, you can't get adjudication. Where did you get the 4-year limited jurisdiction?
Well, that would come from, I presume, the statute of limitations. Would it?
We were going with the longer of the two. So we were,
Well,
but you're right.
First of all, I'm not a fan of 245 to 250. I'll be honest.
Oh, up here.
Yeah, I don't think that should be eliminated. I think that's a different standard. But the 4 years, I'm just thinking that there might be an inconsistency here. If you're trying to group those type of cases, I don't think it'd be very often. But when you have someone who's convicted of offense, but it got reversed on appeal on whatever ground, then as I understand it, you might not be able to get Superior Court to give you remedy within 4 years, because I think that kind of runs it out, unless you have some language in there that accepts it.
I think that I don't know that those are necessarily mutually exclusive, because the 245 to 250 is part of the overall that subsection H that provides what is records that are access to which should be restricted, and that would be part of the mandatory expungements. But we're talking about so if a person fell within that provision, then I believe they would be entitled to have their record removed at any time, even if it's outside of 4 years. But this subsection J is dealing with a special statutory procedure to provide extraordinary relief, and we're just simply saying you've got 4 years to bring your petition.
Okay, that might be the case. I think you might be cutting out maybe it's a narrow group of cases you probably are trying to do to exonerate. But 245 to 250, I think that's a different category from the other ones you listed in terms of mandatory expungement or restriction of disclosure.
You feel like that a reversal on appeal or a vacating of the conviction by the trial court would not rise to the level that it should be automatically expunged?
Right, because I think the other categories are at the probable cause standard, and if you have an individual who's convicted who went through trial, you have several findings as a sufficient evidence beyond probable cause. Matter of fact, at a judgment or acquittal stage, you have a judge making a determination that, viewing the facts, that you think a jury can find beyond a reasonable doubt that person is guilty. So I think that's categorically a different group of cases than the other ones you listed. So I would have little concern about that being mandatorily expunged.
Well, I think that you make a good point, but I would raise the issue about where a case is reversed on appeal for insufficiency of the evidence, and that does occasionally happen. So
I understand that, but that's still a different standard versus, at the probable cause stage when there's grand jury no process twice. I mean grand jury no bills twice, then there's not enough evidence at that stage. But I think fundamentally there's a difference between those type of cases and cases where you always go through all the way through trial, and then there's several determinations that you have more than probable cause and you're actually closer to beyond the reasonable doubt. And I'm afraid that having the language is worded that you might group in those cases when you have technical defects of trials and things like that, and the prosecution only gets one shot at it. So you might be grouping those cases, I think, that probably inherently different from the other categories that you listed.
Thank you.
Good dialogue. Let me ask Ms. Neal if you would just to hold for a minute. We have the room until, which is not a no. We have the room until 2:30. So, with the author's permission, let me ask if the prosecution community would want to be heard generally or specifically, or neither, in general, on the issue. Sure, Mr. McManus, if you'd come forward.
I guess.
And then we can always double back if we've got time at the end. I'm going to have to excuse myself at 2:10. Chairman Ramsey will go ahead and take over then until we finish up at 2:30.
Thank you, Mr. Chairman.
Yes, sir.
Ladies and gentlemen of the committee.
Thanks for being here.
Introduce myself. My name is Kermit.
If you could pull the microphone. Thank you.
My name is Kermit McManus. I'm the district attorney in the Conasauga Judicial Circuit, and I'm here to speak briefly about our position on the bill for the District Attorneys Association, the Prosecuting Attorneys Council. The comments made earlier, I want to clarify the position that the prosecutors have in terms of being involved in the expungement process. We do want to be involved in the expungement process in terms of dialogue on this bill and any changes that are possible to be made to the expungement process. We are I think it was a misinterpretation of some language, some comments made a year or so ago about our intentions. We have to be involved. Prosecutor has to be involved in the expungement process, and we need to be involved. We want to be involved in this process on the vetting these bills that are before the House. And to that extent, we have formulated an expungement group that has been meeting over the summer, including ourselves, district attorneys, solicitors general, GCIC. Dawn is with us from GCIC, Mary Beth Westmoreland from the Attorney General's office, and we're very much involved among ourselves in dealing with this issue. We have some concerns that are shown in both 663 and 402, and as a general proposition, we want to discuss with the other stakeholders, as you suggested between now and January, about language that would be acceptable. We want to have, the word expungement, number one, is an improper term. Restriction of access to records is the way this thing should be going, we believe. We are in the process of, especially working through GCIC, of determining ways in which a lot of these processes can be done automatically and on the front end, so that people won't have to be filing petitions and applications to get records expunged if they fall within certain categories. So as a general proposition, that when the case is dismissed, the case is null pros, that when we file the documents, the prosecutor will be indicating at that time this case can be expunged, and that can be done automatically in and of itself at that particular point in time. The definitions, we think there are some definitional issues that need to be addressed. We're working on those things. We want to keep the law philosophically where it is, and that is, if you look at the exceptions, before a case is indicted or accused, and it's not prosecuted or it's dismissed, that's basically an automatic. If somebody applies, or in our future world, that case is dismissed, it'll be automatically restricted. If it has been indicted or accused, the current list of 7 reasons why the DA or the prosecutor can deny an application for expungement under current law are all related to issues that cause the case not to be successfully prosecuted for reasons that have nothing to do with whether or not they're guilty or innocent. It's their lack of evidence. That's because a material witness is not available. A motion to suppress kept certain evidence from coming into the case. A plea agreement dismissed some cases and not others. Those kinds of things are in current law, and philosophically, we think that should stay. Has the same thing to do with the reversals, as Mr. Pack suggested, on reversals of convictions. There may be very good reasons why a case could not be re-prosecuted after a conviction that has nothing to do with the guilt or innocence of the accused. for the current way this bill is written, 402 would be reversed because of a charge the judge gave to the jury that was incorrect, and it was reversed, but you couldn't re-prosecute it because the material witness is unavailable by death or other means. A lot of issues out there that would, we believe, don't have anything to do with the person's guilt or innocence, and so that those kinds of issues and not guilty verdicts are the same. A not guilty verdict, of course, doesn't mean the person is innocent. It means that the jury or the judge was not able to find proof beyond a reasonable doubt. The state didn't prove it beyond a reasonable doubt, and there could be a lot of different reasons why that acquittal occurred, but doesn't really address whether that person was guilty or innocent. And when we're talking about employers looking in GCIC for records on a potential employee, we think it's vital that they be able to see those kinds of issues that I've just addressed, even if there was not a conviction, because you certainly wouldn't want to have somebody working as your babysitter that had been convicted of child molestation, their case was reversed, or had an acquittal because the child victim was unable to testify appropriately for the jury, or instances like that. So we want to keep that philosophical edge in the bill that says we think restricted access is a good idea and should be done. It should be done automatically whenever possible. For those people whose cases were dismissed, were not prosecuted for reasons that have to do with the innocence of that person, but not because of other issues that may not have anything to do with their guilt or innocence. Other aspects of the bill that have been addressed this morning about the jails and clerks' offices, we haven't gotten that far in our discussions about those issues. We're concerned about sealing records in the clerk's office. For that reason, sealing records in the clerk's office and other parts of restricted access, we want to keep on the forefront that what we're talking about here is government. We're talking about the government keeping information from the public. And we don't believe the government should be in the business of keeping vital information from the public for employment or licensure issues unless there is a compelling reason to do so. Having said all that, Mr. Chairman, what our group is endeavoring to do is to come up with a proposal for a substitute that will outline and be more detailed, of course, of the things that I've addressed with the committee this afternoon.
Thank you for being proactive in doing that, Mr. Sessler.
Thank you. And again, thanks for coming today and sharing the perspective. And I think we're looking first for clarity to understand where the camps are. I think one of the most frustrating things here is that you've got sort of this uncertainty where people are, and then late in the game you think you've got a consensus product, and then boom, there's objection. So it's important we know where you stand. Having said that, my question to you is, whereas I'm sensitive to the issue, the proposition that this is government withholding information from the public, for a person who's been falsely accused, the circumstances could perhaps have been generated by the government. I mean, again, I don't want to use the government in a pejorative term. I mean, our brave, underpaid police officers that do a great job for us, at least certainly in my communities, are certainly not looking to do the wrong thing by anybody. But for someone who's been falsely accused to suggest that, the proceedings that led to an acquittal or that led to something other than the conviction, to suggest that, you really shouldn't have been there doing that anyway. The acquittal, even though there was an acquittal, the information about all the salacious charges that were brought against you, that found out that were determined to be not valid, to suggest that ought to be available to the public, I think is troublesome.
Yes, sir. And if I may respond,
please,
Representative Sessler, both current law and the proposals that we've seen already would not prohibit the restriction of a situation like you suggested. What the proposals are that concern us is for the legislature to blanketly say any acquittal is expungible or restricted. What really is happening, and what happens in current action, is the prosecutor makes the decision. And if we had a case that's as you suggest, where it was falsely accused, then ethically we would be required to grant an expungement under current law, even under those circumstances, because that would be the proper thing to do if it was a false accusation that was proven to be that. But the problem is that we see, part of the problem is that legislatively you're painting with a large big brush, and every case is unique and every case is different. And for there to be, there should be parameters, we think. There should be guidelines, like in current law, as there are, that say these cases can be, the prosecutor can deny restriction under these limited circumstances. Otherwise, they are
But the prosecutor is not the judicial actor. The prosecutor is one of the two sides. I mean, are you suggesting that? Because my concern is that the suggestion that the judge doesn't make these kinds of decisions, that a prosecutor kind of has the upper hand in determining whether there's an expungement or a restriction or not, is troubling to me. I mean, to me, that's akin to the losing team gets to decide whether the highlights are put on SportsCenter, and everyone gets to see them. I mean, if the coach gets to decide if his team's bungled defensive scheme doesn't work, if they get to decide whether the national audience gets to see that or not, you're going to have a lot of things that are not going to make SportsCenter. And I use that as a kind of a glib analogy, but I mean, it seems to me that there ought to always be a judicial actor making that decision, because you've got one side, and I know that prosecutors have a duty as well. I'm not saying that they're purely. We get the balance there, and I get the professional responsibility. I'm just concerned there not being a judicial decision, and I think that's probably one of the roots of this, is that one of the sides in the case, it really holds the key on whether the expungement happens, and that's just. I think that the proposition here is that perhaps there ought to be a judicial decision that's the principal decision.
Well, if you're talking about a judicial decision being an acquittal, a judge's decision, or a jury decision.
The expungement decision ought to be, in my mind, a judicial decision.
Okay. Well, of course, that's a sea change all the way around if we're going to put all this in the lap of the judges. You might want to talk to them about that. Otherwise, the question really comes down to who decides. Is there any other entity in the system that can make these kinds of decisions? The prosecutors have that decision-making process from the very beginning. We have the discretion to go forward or not on the cases independently, because that's the way public prosecution works. Is that we work for the state of Georgia, for all the people, and so we're the independent determiners of what goes forward and what doesn't. We have the ethical obligation that no other lawyers have in determining what goes forward and not. And we make the same determinations at the end if given within those parameters concerning restricted access.
But the concern is, we most folks in the public think about, going to prison's the consequence if you're convicted. But there is a material impact of that information being put out there, particularly as easily available as information is today, that there's a material penalty for even being charged with something.
Yes, sir.
And if you've been charged with something wrongly, or you've seen someone close to you's been charged wrongly, or you've been close to a situation, it's not just the conviction; it's the material impact of ever having been charged with something.
Yes, sir.
And that in itself is a punishment. There's a penalty in itself in that.
Yes, sir.
And recognizing there's a penalty in even being charged with something, the fact that penalty plays itself out and has its impact in the availability of the information. And because of that, I believe that because there's a penalty-like quality to information being made available, that judges make decisions about guilt, innocence, and penalties and those kind of. That's a judicial, whether it's the jury, whether it's the judge, that's a judicial-like decision. And to the extent there's a material impact of information being made available, I can't see how anyone other than a judicial actor can make that decision.
Well, I don't know if you want me to respond to that, but like I said, I think you want to talk to the judges about being in that role, because when you're talking about an expungement, unless the case has gone to a trial in front of the judge doesn't know anything about the case. They don't know anything. They shouldn't. They're not supposed to know anything about a case until it comes before them for evidentiary purposes, for the evidence to be presented to them. They don't know the background of the case. They don't know the background of the individual. The only person that has that information is the prosecutor.
Representative Neal.
My question is in reference to, because I know the past conversation we were having hearing about this, we were having an issue with how we were actually going to physically seal the files or what have you. But I just want to clarify, you don't feel that the files should be restricted in the clerk's office, even in reference to the expunged cases?
We have an issue with that we want to consider. We haven't resolved that among ourselves. We've discussed it. We have our, for lack of a better word, our knee-jerk reaction to that is that is an extreme measure. Sealing records in the clerk's office is an extreme measure, very rarely used, and we would not want to see that become routine for a lot of reasons in terms of reaccessing those files. Beyond just the general proposition that we're really are then hiding information from the public and that is otherwise public information. GCIC is not necessarily public information. You have access codes to get into different parts of it, but clerk's office is open to anyone that wants to walk in there and look at the files. And so restricting that is a little bit different than restricting things in the computer world of GCIC. Beyond that, we're not sure that really answers the question, does it? If somebody is diligent enough to go beyond GCIC and not finding what they're looking for, so they go look in the clerk's office. If you hide it in the clerk's office, don't they have other avenues of finding the exact same information? And the answer, of course, is yes. All they do is file an open records request on the DA's office, and they get everything that's in that file. So the information doesn't go away. It's still there. And so restricting stuff in the clerk's office, we think, needs to be looked at very carefully before you get into sealing records.
Well, I just have a question. Do you think that the codes that we use for GCIC as a safeguard, do you feel that a seal in the clerk's office is equivalent to the same safeguard that would be used on the computer format?
I don't know. I don't know the answer to that.
Okay, thank you.
Representative Pack.
I think we have a different opinion with Representative Setzler. I do think the charging decision has to be in the executive power discretion. I do agree that we need some balancing in terms of when you're looking at rare situations when you're trying to expunge some records. But my question to you is the categories. I know you're going to submit a substitute. Are there categories of the automatic restrictions on disclosures that they've listed in 402 that you have problems with, other than the general philosophical difference that the prosecutors have?
Yeah, I don't have 402 here in front of me. My recollection, though, in terms of cases after indictment or accusation, and they're null prossed or dismissed subsequent to that, current law has 7 exclusions or limitations, and those 7 say that the prosecutor can deny the expungement if it falls under one. If it was dismissed for one of these 7 reasons.
Do you remember that code right off the top of your head?
35.337.
It's on page 4 of your bill.
Oh.
Yeah.
115 to 134.
Yeah, A through G. No. Yeah, A through G. Yeah, 115 to 134 lists the 7 limitations or opportunities that the prosecutor can say, no, this is not to be restricted.
And so
they should be retained. They're not all retained in 402.
So is the proposal going to be to adopt the 7 standard that exists currently, or what do you think?
I think it'll probably be that. Yes, sir.
Quick question about open records access. When you have a case closed for whatever reason, I'm just not familiar with the law on it. If somebody were to make an open records request to the agency, what standard do you apply and what information do you provide to that person requesting?
To the prosecutor's office?
In cases like when somebody's charged and it's null prossed, and a reporter wants to write something about it, what process does the prosecutor's office go through? Well,
we review the file to see. once it's closed, it's open, is subject to the open records request. And somebody that files open records is entitled to almost everything in the file, the investigative aspect of the file, all the investigative reports, any information similar to that is going to be released. What's not going to be released is the GCIC that's in there and work product of the attorney.
One last comment before I move on. In cases, I understand that you want to have as much discretion, but in cases where it's close, when you have evidence that's suppressed or high-profile situation when the prosecutor doesn't think there's enough information to go forward, and you know pros. Do you think that that's like a big fight because of the way the internet is? I think that if someone really wanted to find out if someone was arrested, they could find out. So are we talking about something that's not really going to be an issue from the prosecutor's standpoint, even if it's automatically restricted, disclosed? I guess that's not correct term. I don't know how to pronounce it. The access is restricted. Do you understand what I'm saying? I mean, those politically sensitive cases where you dismiss, I think there's going to be news about it. It's just going to be completely out there.
Yes.
You can't do anything about that.
Right.
So those can't be the areas that I believe the prosecutors are concerned about in terms of being able to keep it open in the public. Am I right or wrong about that?
If once it's dismissed and they file an open records request, it's available.
So what is the compelling state interest in refusing or not allowing the restriction access of accusatory stage things like arrest? I understand you're saying the public has the right to know. And I think those really high sensitive and cases that have high profile, you're always going to get that information going to be out there about the arrest, and you can't do anything about that. So what is I'm viewing the state's interest in keeping that record available on private entity and whatnot is probably a lot less. So what is it? What is the interest in in disallowing like routine arrests that doesn't result in any kind of charge to the access to those records being restricted?
The access to those records, for the most part, from what you're describing, is going to be restricted to employers and licensure groups. If it was dismissed without indictment or accusation, that's just going to be automatic. If it has been indicted or accused, if the reasons for that dismissal, non-pros, whatever it was, is, like I say, under the 7 listed in current law that don't have anything to do with his guilt or innocence, then we have the ability to say no, they're not going to be restricted.
All right, I understand that.
And the reason for that is so that the rest of it is out there. So that information is out there. That person was prosecuted for that charge, for those charges.
Right. So what is the state's interest in opposing the restriction of disclosure? If that information is out there in the public, what is the state's interest in continuing to maintain that those need to be available to the public?
Well, as we talked about initially, the prosecutors in the process, we are the ones that are under current law, and I think in going forward, we're going to be the ones that have to make that decision. What we don't want to have happen is be put in the position of approving the restricting of information that should not be restricted because it doesn't have anything to do with whether the person was guilty or innocent.
I'm sorry, I missed that. Well,
we don't want, in the case, for instance, in current law, somebody applies for an expungement. It comes to the DA's office. We review it, and it was not prosecuted because a material witness was not available to us, and we couldn't go forward with the case. It is our belief that if we are required to say this is to be restricted, that we're lying to the public. Because when we say it's restricted, then an employer looking at a background check is going to see this person has no criminal record. When that's not true, and the only reason he's not convicted potentially is because of something that doesn't have anything to do with his guilt or innocence. And so we think that those things that was what Gary Moss commented about 2 years ago. Mm-hmm. We said we didn't want to be involved. We don't want to be involved in something that's going to put us in the position of telling the public that nothing exists on this guy when in fact it really does, and we're having to say by law it's telling us that the prosecutor's going to have to say yes, this can be restricted, even though we know, and the reason that it was dismissed didn't have anything to do with the fact that he's innocent. But we couldn't go forward with the prosecution because of something that kept us from proving the case and not being able to go forward, not having to do with guilt or innocence, but the issues that are listed in the 7 enumerations in current law.
What would be the situation when the public would ask you directly and then you can't answer them? I mean, can you cite me an example of that happening?
Ask us directly?
Right, because you're saying that you're lying to the public, so I'm trying to find out an example. I'm trying to work with you here because I'm on your side on some of this stuff, but I just don't see I understand the philosophical problem, but there's a practical problem of people not getting hired because they can't, when somebody falsely accuses them of something, they can't get that record erased, and I think we have to balance that. And I understand you were opposed to the automatic erasure of that, so I'm trying to understand the state's interest in opposing something like that when I think a lot of that information by way of technology is already available.
Theoretically, you're right, but our concern is that we are currently, and like I say, I think prospectively, we're going to have to be part of the process. We're going to have to be the ones that make the decision and say yes or no, expunge or not, restrict or not. And if the law is changed so that if it's null pros, we have to grant that restriction, and we know that that person was guilty, we just weren't able to proceed with prosecution because of some of the limitations, like I talked about, those 7 limitations, then we're not stating the truth when we say grant this expungement, grant this restriction, because the law requires us to do that if we change the law. Now we don't have to do that. We can say, not going to grant this expungement because this case was null pros because of motion to suppress relevant evidence, or material witness was unable to testify, or couldn't get him to court, or whatever. Reasons that have to do with why we weren't successful in completing the prosecution, but don't have anything to do with whether this person was guilty or innocent. Understanding, of course, that we always have the discretion to say yes. Application comes in for a restriction of the record, and the reason that we dismissed the case, the reason it was null pros, even the reason it was an acquittal, we could grant it because if we know that facts are this person really wasn't guilty.
All right. I guess I'm going to have to wait till your committee substitutes. I'm still not convinced on the public interest that you're citing. But okay.
Representative Neal, and we've got about 4 more minutes. We've got this room, so we're going to wrap up at 2:30. I think this is going to be the last. I'm going to give the author of the bill an opportunity to if you want to bookend any of this after this last question, but and then let you have the last word to the extent that you want.
I don't really have anything else to add right now. We would look forward to working with prosecutors and trying to come up with something that's that's workable and that respects the need for information to be given to the public that's important for public safety, but also that would respect the rights of individuals who don't pose a threat to public safety to have an opportunity to have their records expunged.
Right.
And along with that, like I was speaking about the GCIC earlier, that's why I was saying if we can make it comparable to where, because like when you do a purpose code for certain things, it restricts certain access. And if we can make that equivalent in the office where if you restrict from these files because it's restricted on the GCIC because of a purpose J code or a Z code, then in the office that same file is restricted or sealed. It's not necessarily blocking everything, but I think it addresses the certain things to make it match versus the electronic form versus the physical, tangible form that's in the office.
I understand.
Yeah.
Well, I'm just going to echo Vice Chairman Hatfield's comment and just encourage the parties. We've got a few more months, and I just from my point of view, I have many of the same questions that Representative Pack was just asking, and would like a better sense for I guess more concretely articulated reason for opposing this kind of restriction that's being proposed, because I'm still kind of grappling with that question myself, and I think Representative Pack did a good job of kind of laying out questions that I still have in my mind, and I'm hearing that from some other committee members as well. I get that sense. So I would just encourage the parties to keep working together. We've got a few months, and to the extent that Chairman Golick wants to schedule a meeting between now and then, I hope he doesn't. and my law partners echo that sentiment as well. But we'll see y'all in January, if not before. So.
Thank you.